What does repeal mean in statutory law? Imagine a law that was once part of the legal landscape suddenly vanishing. That's what repeal is all about. When a law is repealed, it is officially canceled by the legislative body. This means the law no longer has any legal power or effect. Think of it as erasing a rule from the rulebook. Repeal can happen in different ways. Sometimes, a new law explicitly states that an old law is no longer valid. Other times, a new law conflicts with an existing one, and the older law is considered repealed to avoid confusion. There are two main types of repeal. Full repeal means the entire law is canceled and has no effect anymore. Partial repeal only removes certain parts or provisions of a law, leaving the rest still in force. Repeal can be clear and direct, called express repeal, or it can happen indirectly when a new law conflicts with an old one, called implied repeal. In courtrooms, repeal is very important because it tells judges and lawyers which laws they can use to settle disputes. If a law has been repealed, courts will not enforce it anymore. But if a law is repealed and then later the repeal is also repealed, the original law does not automatically come back unless the new repeal says so. Repeal helps keep the legal system up to date. It allows lawmakers to remove outdated or unwanted laws, making sure the rules reflected current society's needs. When courts are deciding cases, knowing which laws are still valid is essential. Repeal is a way for legislatures to clean up the legal code and make sure only current laws are in effect. So, in simple terms, repeal means the formal removal of a law from the books, making it no longer enforceable, and this process shapes how laws are applied in courtrooms every day.